Yes, Mr.
May it please your lordships, in this appeal, I appeal for the appellant, Secretary of State. My learned friends, Mr. Shirako, King's Counsel, and Mr. Hodgetts appear for the respondent. On housekeeping matters, my lords, your lordships should have a core bundle, a supplementary bundle, and an authorities bundle.
Well, we do, but I'm afraid you and those behind you will probably know that it was a real struggle getting them. Authorities bundles and supplementary bundles should be filed, I forget, it's 28 days, 14 days for authorities and 28 days for supplementary bundle. We only got them last week. And in the case of the supplementary bundle, in hard copy, because we don't all work from soft copies, although it was promised for Friday, it didn't arrive till yesterday, and then we had to be printed up in this end. It's just not good enough, and I don't quite understand why, as regular litigants, the government legal department can't get these things right.
I do apologise, my lord.
Well, I don't want to, I'm sure there are reasons, there always are reasons, but if things are started in good time, there's less chance of us having to, it makes a real difference to us because we're trying to read into the papers and we haven't got things we can mark up. Our clerks are scurrying around trying to find out what's happening. It's not satisfactory. Okay, I've got it off my chest.
No, I apologise. I didn't say that. And I'm afraid, my lord, between us, we also omitted from the bundles a small number of documents.
Including a respondent's notice, or rather key document in this case. Isn't that in the bundle? Where in the bundle is the respondent's notice?
It's not, we've got the skeleton not.
Oh.
Sorry.
I thought I'd done enough ticking off, so I wasn't going to descend into particulars, but that did strike me as a bit odd.
Yes.
I think we know what's in it because of the way it's argued in the
Yes,
respondent's
and
case.
I went on to file and printed it out, but I shouldn't have to do that.
No, of course. No, I am sorry.
No, well, don't worry.
It's-
What else have we not got that you think we should have?
There are two further authorities that the party should bring to the court's attention. There's also the nationality policy on renunciation, which my friend wishes to refer to, and we haven't included. And I'm afraid we also realised that this morning that although your lordships had the submission, the principal submission of December 2020 to the Home Secretary, the annexes were not all there.
No,
we're not in
they're
one
very
place.
fully set out by, I forget which, the Upper Tribunal, I think, not the OTT. But again, I did notice that, but I thought that was a considered decision. But if you want us to see them, we better have them.
May I hand up 3 small files? We've just, for the sake of tidiness, we've just added the annexes to the end of the authorities bundle, simply so we've got any
Whatever
index.
works, that's fine.
I'm grateful. No, I am sorry about this, my lord, because it shouldn't have happened.
Well, can I say also that we have control of the electronic version of the authorities bundle for the respondents. So if it will help you, we can amend the electronic bundle to add in those 4 documents and to amend the index. I don't know whether you are.
Well, I tend to work from the hard copy, but it is occasionally useful to have them available electronically. So if you wouldn't mind doing that, it's
We'll do
truly
those
very
in the
small.
In the course of today, if in the course of
Thank you.
just after the hearing.
Oh, I see. So I see. So these, we need to do it now, but in principle could just be stuck at the back of the. Yes, well, okay. I'll keep this out for the time being. Thank you. What should we call this for the time being? Just the new one?
Authorities 2?
Well, it isn't really authorities, is your point?
Well,
Okay, authorities too. Yeah. Right, substance.
my lord, if the court is content, my learned friend and I propose that I would deal with the Home Secretary's ground of appeal. He would reply, he would respond, and then deal with his own grounds of appeal.
Yeah, that's fine.
And I respond. My lords, have your lordships had the opportunity to read the ministerial submission of December 2020, the decision letter, and the ruling of the Upper Tribunal?
Yes, had it undertaken it.
Grateful. My Lords, the Home Secretary's point is a very short one. It is simply that in the Home Secretary's submission, the Upper Tribunal applied far too strict a test to what is required of a decision letter. I think it's common ground that there is no public law duty to give reasons, although there are instances in which procedural fairness may require reasons to be given.
Is it common ground? There's no public law duty to give. There's no statutory duty to give reasons.
No statutory duty, but also
Sorry, my Lord, our position is there is a statutory duty to give reasons in section 45.
Oh, yes, quite.
I accept that entirely, my Lord.
(45B).
45B,
Yeah.
the reasons for the order. And in my submission, what is required there is exactly what has been complied with and has been done in the decision letter. In other words, you have been deprived of your citizenship because it is conducive to the public good. You've been involved in serious organised crime. The individual concerned therefore knows immediately the reason. What is not required by statute or common law is a detailed step-by-step description of the process.
Is that what has been, as I understand it, the criticism is not that it wasn't detailed or step by step, but that there were, but that the exercise necessarily involves two elements. One, that your the deprivation is conducive to the public good, and secondly, that as a matter of discretion, you having that condition being satisfied, you've decided to deprive. And what you do need, it is being said, is some indication that you have, may not have to be structured in this way, but some indication that you have considered the exercise of that discretion and addressed any matters that obviously have to be addressed. What those matters would be would depend on the circumstances of the case. I think that is effectively what the Upper Tribunal was saying and what Mr. Jericho is seeking to, what Mr. Jericho says as well.
My Lord, yes, the Upper Tribunal said there does not appear to be anything within the respondent's decision to give us or any reader confidence that the respondent was aware of her discretion or that she exercised it in the appellant's case.
Yes.
That's paragraph 62, which is at page 78. Or bundle.
Yeah. That is what they said.
It is.
What's your answer?
My lord, that there is no obligation for a decision maker in this, or indeed most other public law cases, to spell out the words, "I have exercised my discretion." Because if it were the case, then the administrative court would face a backlog from here to eternity.
Well, I don't think they were saying that you must use that form of words. They said there'll be something in it that indicates that you have, that you do appreciate you have a discretion and have exercised it. And if there are substantive reasons, to give them.
And in my submission, my lord, the decision letter does exactly that.
Where?
Initially, in the first paragraph, it makes clear that the Secretary of State was aware that she had a decision to make. She has decided to make an order.
Yes.
Because it's
Well, obviously, that's obvious. Then she goes on to say, because I'm satisfied it's conducive to the public good to do so.
which is, but arguably, which as the Upper Tribunal considered, reflecting only the first part of the test.
Yes, quite.
My submission is, my lord, if one looks at the letter as a whole, it's clear that there is more than that. Because the letter goes on to deal in the next paragraph with the seriousness of the offending. Then its categorisation as being participation in serious organised crime. Then an express statement that it is this offending that leads the Secretary of State to conclude that deprivation is conducive to the public good. And then the Secretary of State goes on to deal with matters that could potentially lead to a decision not to deprive. So first, I'm satisfied that such an order will not make you stateless. Therefore, that's been expressly considered and excluded as a reason. And then she goes on to deal with Section 55 and the best interests of the children. And again, this would be an area in which the Secretary's discretion was highly relevant. She has to consider the best interests of the children, and she deals first with the fact that deprivation in itself will not have a significant effect on them.
Yeah. At para 62,
Yes.
The Upper Tribunal gives some indication of the sorts of things that it would have expected to be dealt with as part of a reasoned exercise of discretion. In the second paragraph, second sentence, it says, she, that's Secretary of State, was presented with a range of material in the briefing documentation which he was given in relation to the appellant's risk of future offending, the question of the potential impact of the decision on the appellant's human rights, and the potential impact of the decision on his family, and in particular his children.
Yes.
And as you've shown us, the family and children are dealt with. What about the other two factors that are referred to there, or any other factors in the briefing materials which the Upper Tribunal thought ought to have been dealt with?
My Lord, first of all, my submission is absolutely no obligation in public law for the Secretary of State to set out every single factor that she considered. And secondly, the court could and should infer that the Secretary of State took into account all those matters that were put before her in the very extensive submission of December 2020.
Do you have any authority to support either of those propositions?
My Lord, no, this simply is a matter of general principle. And my submission is there is no public law obligation to set for any decision maker to set out.
So going back to Lord Mustill and what is fairness?
Yes.
Right, okay, thank you very much.
It's a bit odd, though, to put it that way, isn't it? In circumstances where the briefing material is not made available.
My Lord, my
If
submission.
your obligation is to give reasons, you can't get over it by saying, "Oh well, I thought about lots of other things, but I didn't mention them in my letter."
My Lord, my submission is that the obligation to give reasons is to give essentially the key reason. This is conducive to the public good because of your serious offending, which is contained within the letter. And then the other key factors that the Secretary of State has taken into account have been included. And it's not unusual at all in judicial review for the court to examine material before a decision maker. There's no
It
obligation.
depends what the issue is.
It does.
If the issue is whether you've given adequate reasons, I'm not sure it's relevant to look at the material that was before the decision maker, except to see what are the points about which you should have given reasons. But it won't answer the question whether you did give reasons.
No, it won't, my Lord. But it will answer the question as to whether the Secretary of State properly took into account everything she should have taken into account.
But that isn't a considerate.
Well, paragraph 62 is really wasn't aware of discretion, didn't exercise it, rather than no reasons.
Yes, and my submission is that it's clear from the face of the letter that she was aware that she had a discretion and exercised it. Because the issue of statelessness and the interests of the children were both matters that would have indicated.
My Lord is right to remind me, in fact, the Upper Tribunal put it both ways. And 62 is, as he says, a failed to take into account. And para 63 is, even if we're wrong about that, no reasons.
My Lord, yes. But my submission is that the reasons are more than adequately set out in the decision letter. The individual concerned knows exactly why the decision has been taken. There's the obligation in section 45, and my submission cannot be construed to include an obligation to set out in immense detail every single factor.
That's a straw man. Nobody's suggesting you should set out in immense detail every single factor. Got home on a sentence or two.
My Lord, so that there must be therefore a sliding scale of what amounts to compliance with the section 45 duty to give reasons. And in my submission, this letter clearly complies with it.
I'm actually wondering how much of the material in the briefing documentation was actually decisive, or was actually relevant, except to the question which he does give reasons on, which is the conduciveness question.
Well, the annexes.
One of the oddities about 42, it might be thought, is that although clearly there are some discretionary matters which are separate from the conduciveness question, many matters that could be said to be discretionary are actually relevant to and built into the conduciveness judgment.
Yes, inevitably. A lot will depend on the information before the Secretary of State about any individual at any one time.
Yes, thank you. I'm sorry, we've done that rather Socratically with the question, but have you made the points you wanted to make on that?
My Lord, yes.
Do you want to show us the briefing material and the annexes which you've given us now and we haven't had a chance to read?
Yes, please, because your lordship said that most of the material in the main paper dealt with issues going to conduciveness, which is right, but it is the annexes that deal in more detail with the other issues.
Okay.
With statelessness, which is Annex B, and that's at tab 22, and what we're calling authorities 2.
Can we just be clear about this? Statelessness isn't an issue, is it?
It's not, but it is an issue that the Secretary of State has to consider.
Yes, but the Upper Tribunal did not put you down on the basis that you didn't consider statelessness.
No, because we did. It's clearly referred to in the decision letter itself.
So anyway, show us what you want to show us in the annexes.
The annexes, Annex A was already in the bundle, but it's more convenient to deal with them all together. So Annex A is from the NCA, and that does deal with the offending. Then Annex B is internal page 37. Deals with the risk that Mr. Kolicaj might be stateless or might become stateless. Of course, if he were stateless, the Secretary of State would not be able to exercise her discretion to deprive him of British citizenship. So Annex B deals with the Secretary of State's current understanding of Mr. Kolicaj's factual situation and the law of Albania in paragraph 3, 4 and 5.
Hang on 1 second.
Sorry.
Yes, actually, well, we haven't seen. Fine. Yeah, thank you.
And then it goes on at paragraph 7 to give advice to the Home Secretary. Well, there's always a risk of it emerging at some time that Mr. Kolicaj doesn't, for whatever reason, hold Albanian citizenship
Well, it's not quite what it puts. It says has somehow been stripped of it.
already. Yes. But the current position is, the advice to the Home Secretary is that deprivation would not render him stateless. Then Annex C consideration of Articles 2, 3 and 8 of ECHR. And again, any issues suggesting that deprivation of British citizenship might lead to a breach of any of those articles would be very significant factors leading the Secretary of State to exercise its discretion.
Well, hang on. Can I just be clear about this? Annex C covers deportation and deprivation.
It does.
And although it is clear that the Secretary of State was intending to deport, or was minded to deport, once deprivation had occurred, is it not the case since, is it AB? I get confused with all these letters, but Lord Justice Sales said that, except in exceptional circumstances, in deciding on the lawfulness of a deprivation decision, you shouldn't get involved in the deportation
That's right.
question, proleptically, as he puts it. And does that apply here? I mean, I rather assumed we're only looking at the effects of deprivation as such, and the effects of deportation would arise in a separate challenge to the deportation notice.
They would. And the information.
I don't know. I'm not sure we've been told. Is there one?
Sorry, is there a deportation?
Is there a? No, I think we have been told that a deportation notice was served, haven't we?
My lord, yes, and the deportation, it's been appealed and the appeal has stayed behind these proceedings.
Yes, I see, thank you. Well, that would be the vehicle for Article 8 challenges based on the effect of deportation. Article 8, 40, well, can't see Article 2 and 3 will never arise in relation to mere deprivation.
No.
Article 8 can, but only in rather specific, only effectively because of the limbo issue, because there's case law of the, I'm just saying all this to make sure we're on the same page, and it's obvious stuff. Deprivation of nationality is not as such, doesn't as such engage Article 8, there's a Strasbourg authority to that effect, isn't there? So it's only because of some particular consequence.
Yes.
And in this case, we're talking basically about limbo period. Have I ever got that right?
Yeah, absolutely, my lord.
Yes. Okay, thank you. Sorry. So we can ignore this or any of this insofar as it relates to deportation.
Yes. So
Which are the bits which refer to limbo period?
Above paragraph 7, isn't it, where it says deprivation and deportation, both in Article 8.
and 8. So presumably the Article 2 and 3 regard to deportation was put in sort of to give the Home Secretary further background information, but it was not directly relevant to the decision being taken. But then Article 8, from paragraph 7 onwards, expressly deals only with deprivation.
7, I'd seen referred to. I haven't had his name interesting to see it in the flesh. The second sentence of 7 says he will have the opportunity to make representations against each decision. But that we'll be looking at that again in the respondent's notice context. Yeah.
Well, can I just ask a question on that? I mean, we've got Annex E, which was the letter that was sent anyway. Why is it headed notice of intention to make a deprivation order rather than deprivation order?
Because, my lord, the two are separate, and until the case of the Rochdale child sex exploitation ring were done very far apart. So the notice was given to give the opportunity to an individual to appeal against the decision.
Yes, but hang on, it's not quite that either, is it? The statutory scheme is that there is a decision,
Yes.
not a notice, not an intention, not a minded to. There is actually a decision. Then notice of that decision once taken,
Yes.
and then separately a deprivation order.
Yes.
And again, we may want, maybe now is the time to do it. How at the time of the Lacey, I don't know how to pronounce these names, I call it the Lacey decision, we were told, and it appears in the judgment, that the Secretary of State's practice was to, having sent the notice of decision, not to make the order until appeal rights were exhausted.
That was the practice, yes, my lord.
So the practice has changed, has it?
Yes.
Do we know when that happened?
It's within the last 5 or 6 years, my lord, and it arose in the Rochdale cases because what happened was that on being given the decision, a number of the Rochdale child sex offenders swiftly renounced their Pakistani citizenship, or purported to do so. And so it was recognised that there was a problem, because then by the time the Secretary of State came to make the order, the individual was able to say, well, I'd be stateless because I'm no longer Pakistani.
And the view was taken, I've not seen it challenged, that although the previous practice had been to allow that interval, there was no reason under the statute to do it.
Yes. And one could follow immediately after the other, which is what happened here. It happened within minutes. So the order was made within, I think, half an hour and served on the individual, on Mr. Kolicaj.
In that case, what's the purpose of having two decisions? You might think the purpose of the decision was, the purpose of this structure was a decision to make an order, but no order, notice of that decision, so that you can appeal. Everyone seems to agree the purpose of 45 is to make an appeal possible.
Yes.
And one might have thought that the purpose of the structure, therefore, was that the actual order wouldn't be made until after the appeal, which is apparently what the practice was until a few years ago. What's the purpose of having the 45 procedure if you make the order within minutes of the notice?
I suspect my
Because
lord,
you don't, I'm sorry, of the decision. Because you're not appealing against the order, you're appealing against the decision.
yes, and the order takes no effect while the decision is being appealed.
Where does that come from?
In practice, the Secretary of State takes no action on the order, and sometimes the judicial review is...
Mr. Chirico is busting.
Yes.
I'm not going to allow him to. We say practice takes, but that's once he's made an order, the order is self-executing, isn't it?
Yes, it is.
You at the moment of the order, you are no longer a
You are
British
not.
citizen.
Yes.
To say he takes no action, I don't really mean. You may mean he doesn't take any action to deport, but we're just talking about deprival here, or deprivation, and that happens at the moment of the order. So you've got the way it's worked now. You've got a decision followed within instantaneously or accompanied by a notice, followed within minutes by an order, and then an appeal, which will result in the decision being overturned, if it is overturned. And that presumably also, though rather oddly, it's not how it's structured, also gets rid of the order.
Yes.
It all seems a bit incoherent.
It is, my lord. I assume because Parliament did not envisage the problem that in fact turned up between...
Well, I'm almost certain you're right, but obviously when problems occur, legislation could be amended. Because can you just look at paragraph 7, the second sentence? I suspect this is from a template which has existed since time immemorial, because this is now inaccurate, isn't it? Because it says he will have the opportunities to make representations against each decision. Well, he doesn't have an opportunity to make representations against the notice of intention to deprive if 30 minutes later he gets the deprivation order. So do you know why that's there?
I don't, my lord.
I mean, we've obviously only seen this morning, and so I'm sorry one couldn't give you notice, or more importantly, those sitting behind you, notice of that question. But it doesn't look as if anyone's really worked out the scheme now that, for understandable reasons, in the light of what happened in Rochdale, practices have changed.
And it is still open to the Secretary of State to receive further representations. I would need to take instructions there, my lord.
Well, I appreciate that, and when you're doing that, without sorry to overload, because it does go into the appeals issue. Obviously, if for good reason, if there is a good reason, and I understand Mr. Chirico disputes that, and that we'll obviously hear that, but if for good reason there is a reason not to tell someone they're about to be made deprived of citizenship, that means that they can't make representations. And that has an immediate effect on whether, if the appeal is by way of review only, see Begum number 1, anyone can take into account all Mr. Chirico's points that he would want to make on behalf of Mr. Kolicaj. And I suppose you're going to tell us the answer to that in your reply to Mr. Chirico, are you? Excellent. But sorry, because it just ties in with this second sentence in paragraph 7, which I don't think can be right anymore.
I think it would be helpful for us to be told when the Secretary of State's practice changed. As I say, it must be post-Lacey, because we were told that and set it out in the judgment. You know, the Secretary of State's practice is not to make the order until appeal rights are exhausted, which seemed to us rational and might have made it easier to argue, well, you don't have to give reasons beforehand because nothing will happen until you've had an appeal against the decision. But that's becomes a more difficult argument in light of the current practice, as my lord is pointing out.
Yes,
So,
I can-
will you let us know when that practice changed?
I can do that, my lord. I was involved in the Rochdale paedophile cases, so I just cannot remember the date. So
No,
I can do it when I look it up.
Could we also be told whether the practice applies to all people who have dual nationality, wherever their second nationality is, or whether there is some distinction between jurisdictions where it may be possible to renounce your citizenship instantly, and other jurisdictions where that's not allowed? Does it apply everywhere, in other words, is what I'd quite like to know.
My understanding, my lord, although I'll check it, is that it applies globally because the Secretary of State does not investigate how long it might take any particular country to permit renunciation, or indeed what its arrangements are. The Secretary of State does check whether dual nationality is permitted by a state, and that feeds into the Annex B on statelessness. But she does not go on to investigate the mechanisms of renunciation in any state.
Once you're doing the one, it might not be all that difficult to do the other. Especially with nationalities, I mean, this phenomenon of Albanians claiming, I'm confusing our two groups of cases, aren't I? As you know, my lord and I are also dealing with Albanian cases on 40 sub 3 for deception cases. But perhaps that distinction doesn't matter. The point is the Secretary of State has a comparatively large number of Albanian cases and is pretty familiar, I suspect, with Albanian immigration law and nationality law. For that reason, it's not a huge burden to discover authoritatively what the position is about renunciation at the same time as it's establishing any other questions about statelessness or loss of nationality for other reasons, which we see is actually addressed in Annex B.
My lord, and I was perhaps more intending to come to this in reply to my learned friend who...
Yes, all right. Well, it's useful to you to have a little bit of time to think about these points, take instructions.
Certainly. But the Secretary of State's position is it is actually really quite difficult, as the Pakistan cases showed, and we've put into the authorities bundle one First Tier Tribunal case, not as an authority for the legal principles, but as an example of exactly what happened when issues of renunciation from one of the Pakistani child sex offenders occurred.
What did happen?
What happened was, in that case, after the...
This was Pakistani case.
Pakistani case.
Yes, right.
After the decision to deprive, there was purported renunciation, and then there were of Pakistani citizenship, and then there were arguments about whether or not that could be undone. Had the appellants given Pakistan authorities an assurance that they had, what they had to, in Pakistan, you have to say that you have assurance of citizenship of another country, but they'd had the notice to deprive. So does that mean they'd lied to the Pakistani authorities? If they had lied to the Pakistani authorities, was there a mechanism in Pakistan by which their renunciation could be undone? And in fact, those issues were never resolved and it became horribly complicated. And you then also had difficulties in states without a reputable legal system, difficulties perhaps of corruption, and also, of course, the very real prospect that a state could change its laws, which it could do at any time it chose.
It might be thought that this change in practice as to how Section 40, subsection 5 is going to be applied to all dual nationals wherever they come from all over the world is a significant thing, because it results in everybody being deprived of an opportunity to make representations. It's a bit surprising it isn't written down anywhere as a policy, which could just be shown to us, isn't it?
My lord, it developed, from my recollection, very, very quickly. It actually developed during the course of the hearing, the Court of
Yes.
Appeal.
Well, once
So-
that's how it started.
Yes.
But once in a crisis, the policy had changed, or the practice had changed. So as not to prejudge the answer to this question, you might have thought that, but it was then decided this is how we'll do it for all cases in the future. That becomes a policy.
I'm not sure there's much further I can take that, my lord, because it has developed as a practice. As I understand it, this has developed as a practice.
You don't know. I mean, it's nowhere in the public domain. Or you noticed. You're not aware of any document in the nature of instructions to caseworkers or whatever saying from now on what we're going to do is serve the deprivation order a scintilla temporis after we've served the notice of the deprivation decision. Because that was a change in practice for what you've told us, and as I say, and you would have thought that people would have had to be told that practice had changed, otherwise they wouldn't do it.
My lord, I cannot honestly say whether or not I've seen a document like that, I'm afraid, because there probably were documents at the time of the Rochdale decisions, but I just no longer.
Okay, no, well, fair enough. You weren't expecting these points because we've only seen the annexes, which I'm glad we have. I think, yeah.
You told us that we should, when reading the Upper Tribunal's criticisms of the notice, we should take into account the fact that Secretary of State has seen these annexes.
Yes.
The annexes tell her that Mr. Kolicaj is going to have the opportunity to make representations before a deprivation order is made. Mightn't you expect her to say something about that, if she's really taking these annexes into account?
My lord, she's being asked to make a decision on the basis of the information currently available to her.
Yeah.
And in my submission, it would place an unrealistic burden on any decision maker for anything other than the key reasons for a decision having to be set out.
It might not require very much, might it? It might just be, I haven't given him an opportunity to make representations, but actually nothing that he could possibly say, given the seriousness of what he did, would affect the outcome of this, and anything that he wishes to say about his family circumstances would be taken into account if and when any attempt is made to deport him, and therefore I'm going to make the order. That would probably suffice as reasons, wouldn't it? It's not much of a burden.
My lord, one could probably say that about every single aspect of a decision where the decision maker has not written down exactly or has not reflected exactly what is set out in the submission. The submission is lengthy. It comes with 4 annexes of information plus the draft letter. So my submission, my lord, is that the letter should be read as a whole and in the context of the information available to the Secretary of State.
Just while we've got this, sorry, unless my lord wanted to.
No, I've finished. Absolutely. Thank you.
On para 10, I'm disappointed I've made to you already, but I see it's. Is it helpful to the Secretary of State to be told what the likely position is on deportation? Kolicaj may argue that deportation is a reasonably foreseeable consequence of deprivation. And then this point is fair enough, as he will be served with the liability of deportation notice once he's been deprived of citizenship. It's acknowledged there's an intention to deport them to Albania, fine. He'll have the opportunity to make full representations in regard to the decision to deport him, and then goes on to give a preliminary estimation of how likely that is. This is a genuine question because I haven't really quite thought this out. So, is that helpful to the Secretary of State for the decision she's being asked to make now, to be told that, which Lord Justice Sale says is really irrelevant and possibly distracting when considering the decision whether to deprive?
My lord, I submit it is, because imagine that paragraph 10 said actually deportation is completely out of the question for the foreseeable future because Albania is in a state of civil war or whatever. So if there were good reason why deportation was never going to happen, then that would be a good reason not to deprive, because then you'd have a very predictable limbo situation.
No, well, you'll have a limbo situation. Surely this is the right way to approach it. A deportation decision has not yet been taken.
Yes.
And again, this is actually what the letter said in Lacey. It said, we'll think about it quickly, and we'll think whether either we're going to try and remove you, or whether we're going to allow you to stay, and if so, what kind of leave to remain to give you. Now that's perfectly coherent and workable. It does. The only problem is it creates a period while she's thinking, when they can't have a bank account and they can't be employed and they can't have a driver. You know, all those restrictions. And the Secretary of State has been alive to that for some time and has basically said, I'll make up my mind quickly. And in the meantime, normally it won't create real problems for you. And if it does, it's your own silly fault. It's your own fault for having deceived me. Or,
Yes.
or being a person who we'd rather have out of the country.
Yes.
Or rather not have British nationality, I should say. That's all workable, isn't it? And means that you don't have to decide what your decision is going to be. It just says we will make up our mind about it separately, but soon.
Well, my lord, it's absolutely clear in paragraph 10 that this is no more than a preliminary assessment. Is that Home
Well, what's the point of it is what I'm trying to get. Why do you even need a preliminary assessment at this stage?
Because if deportation were not going to be, I'd rather conscious I might be giving evidence here, my lord, but the obvious response, my lord, would be if deportation is never going to be an option, then the Secretary of State should think very carefully about deprivation. Because
Is that right? Certainly in a 43 situation, there's a principled reason for depriving someone who you're never going to remove, namely that you have achieved important status, namely British nationality, to which you're not entitled. And that is a reason why you'd normally deprive anyway.
and it might. Sorry, my lord.
And 42, it doesn't say satisfied that deportation is conducive to the purpose. In principle, under 42, you could say, person who's done these terrible things or has these terrorist associates or whatever it might be, should not be a British citizen.
Yes, and the Secretary of State.
And irrespective of whether we're able to deport them.
Yes, and the Secretary of State would be able to take that into account. Even if told deportation is never going to happen, the Secretary of State would be able to say, even so, and even though I recognise the limbo difficulties, I'm going to do it.
We haven't got AB in the bundle, have we? That's the one where Lord Justice Sales says keep the two questions separate.
We don't have it. I think it's been said elsewhere too.
Has it?
Yes.
Well, it's AB that I remember, but I'm sure you're right.
We think it's Aziz.
It
It's
certainly,
Aziz,
it
is it?
certainly has. Which
I'm
is
sorry,
why
I do get muddled about it. We haven't got that either, have we?
we don't have it, Aziz, because that was actually the case I did in the Court of Appeal, which led to the change in POC practice right in the middle, and it certainly was said in Aziz.
Well, actually, we can tell where it was because I set it all out in Lacey, and it is indeed as it is. It's para 25 of Lacey.
I'm grateful.
Maybe that's all we need. He said, in my view, the guidance in Delia Lisi on this point, which is that you should always look at whether there will be after-date problems caused by deportation, is liable to mislead tribunals in appeals concerned with deprivations of citizenship, although in a sense it's difficult to quibble with the formula that regard should be had to the reasonably foreseeable consequences of deprivation of citizenship. An examination of such consequences is only required insofar as it's necessary to make an assessment in relation to them in order to rule upon whether the making of the deprivation order itself will be lawful and compatible with the reasons with Article 8 and Section 55. That in turn on the reasons put forward by the Secretary of State to justify the making of the deprivation order as distinct from any deportation or removal order which might be made at a later time. He went on to say, at least in the usual case, the issue of whether the appellant should be deprived of his or her citizenship and whether they should be removed are distinct, and it was neither necessary nor appropriate. Well, I don't know how much we're going to have to go down this route, but it is all, I think, connected with how the decision making was done in this case. Anyway, there we are. Thank you. It is Aziz. If you think we ought to see more of it than appears in Lacey, fine. Otherwise, I hope I quoted it correctly there.
My lord, the only further thing I would say about paragraph 10 is in my submission that it cannot render the decision unlawful that the Secretary of State was given this information
No.
about potential for deportation.
And Annex D is the Section 55 assessment,
Yes.
which is referred to in the decision letter.
In the decision letter. And my submission clearly shows the exercise of discretion.
Thank you. Well, we went to the annexes at this stage. We hadn't seen them before. They've gone a bit further from your core point on the appeal. Is there anything else on the appeal you want to say?
My lord, no, not at this stage.
Could I just ask for your assistance on how this, the decisive point before the Upper Tribunal, how it actually arose? How did it come into the forum that the Upper Tribunal was deciding whether the fact that the Secretary of State hadn't mentioned discretion in terms in the notice rendered it unlawful and void? Who was making that up? When did it start?
Well,
Did it start with the tribunal? I don't know where it came from.
my lord, as the late Majesty said, recollections may vary. My recollection was that it was raised at the first time by the tribunal itself, but I see my learned friend in his skeleton doesn't agree with that.
No, I noticed that. That's really why I'm asking for just what you say about that. But that's your recollection.
It is.
We've got the 87 to 89 of the core bundle, the renewal grounds from the FTT to the Upper Tribunal.
My lord, so the recollections are the same insofar as that we agree that that was raised for the first time at the hearing.
By whom, though?
So my recollection is it was raised by me, but it was raised in a conversation between myself and the panel.
Yes.
If I'm not sure that either of us thinks that necessarily makes a difference in my lord, but clearly you're concerned to know that I'm afraid that we do have a different recollection about this. It arose at an early stage. I put in a short submission overnight, and it arose out of that. And the short submission drew attention to the two separate stages of the Section 42 decision. It was in conversation about that submission arose and took quite centre stage before the Upper Tribunal on that occasion. Is that fair? I think we don't remember who. We don't agree. We don't have the same recollection as to who.
Well,
said the
that may
sentence
not
first.
matter, but you set the ball rolling, you say, but it was during the hearing, the Upper Tribunal, that you did that.
It was by a document that I prepared overnight, which the tribunal saw for the first time on that day. So I accept that.
The original grounds were not amended.
The original grounds weren't amended.
No. Grounds of appeal, I mean. Yeah.
No, that it might be possible to work out that the issue had been foreshadowed in the grounds of appeal. I haven't gone to try and do that forensics search. I'm not sure how productive that would be, because I certainly accept that it only came to the fore on the day in the hearing.
And my lord, I think neither of us thinks that anything really turns on that, because I would hate any difference of recollection between us to make any real difference, because I would not say that I'm certain enough in my recollection of what happened, of exactly what happened or how it arose.
And nor would I. In all honesty.
So it's common ground, basically, that it came up for the first time at the hearing in the context of a further submissions that you put in overnight.
Yeah.
But exactly how in the dialogue between you and the tribunal the point emerged, neither of you are confident to say which it was.
That's a very fair summary, my lord. Yes.
Thank you, that's all I wanted to explore.
Well, on the structure that the two of you have agreed, which we're content with, you get the chance to respond on the appeal and open your respondent's notice point.
My lord, yes, I'm grateful. Could I possibly step forward and get a glass of water from them?
Yes, of course, or I'm sure they are. Oh, well, then, self-help is allowed.
Thank you, my lords. Yes, so GK's position in summary is firstly that, so on the Secretary of State's appeal, that the Upper Tribunal was entitled and was right to allow GK's appeal against the decision to deprive them of his British
You're
citizenship.
calling him GK for short. There's no anonymity order in place.
There's no, Mr.
That's
Collins.
fine. I don't mind. I just didn't want there to be any misunderstanding. Yeah.
Sorry, I'm calling him
No, that's
Mr.
fine.
Kolicaj. And for the two reasons which are given in paragraph 61 to 68, firstly, the failure to exercise the discretion reason, and then secondly, in the alternative, the failure to give adequate reasons. We say that the Upper Tribunal was right to reach both of those conclusions. And then just to introduce the respondent's notice points, firstly, the first of those is that Mr. Kolicaj was given no notice of the decision to deprive him. We've seen that. He was therefore denied any opportunity to address the Secretary of State before a decision was taken adverse to him. And we say that in all the circumstances of his case, that was procedurally unfair and amounted to a breach of natural justice. And we say that the Upper Tribunal was right to hold at paragraph 57 that the Secretary of State was required to establish a clear justification for the departure from the normally applicable principles, but we say the Upper Tribunal was wrong to conclude that the Secretary of State had in fact established that. Our fallback position on this has always been, and that does feature in the grounds throughout, that an alternative means of meeting the overall requirement of fairness would be a process more like what happened, more like the SIAC process, where there is, once the appeal has started, there is a procedure for submissions to be made and a full review to be taken by the decision maker, in this case the Secretary of State. So fairness could, we accept, would be, or at least the balance could be shifted when analysing whether the whole procedure is fair. The balance could be shifted if the tribunal had a process for the admission of submissions with the Secretary of State required to conduct a review, a substantive review. That's not what happened in these proceedings, and as far as we know, that's not what happened.
Sorry,
before the tribunal.
but we accept the fairness to be achieved if what?
So we say firstly that fairness is not achieved because the Secretary of State simply hasn't justified the change in policy.
Yes, got that.
Examined. It might be that the Secretary of State would have a stronger argument, stepping back and looking at the procedure as a whole, if there was a guaranteed review. So if when the Secretary of State is told Mr. Kolicaj will have the opportunity to make representations, if that was a meaningful process, that there were further representations made, that the Secretary of State was required, and the Secretary of State as the only decision maker, because Cartona doesn't apply here, the Secretary of State was required to review substantively and take a supplementary decision. We recognise that that might be a route to a fair system.
Would another route to a fair system, if it was permissible with the jurisprudence in Begum number 1, be to say, well, you have effectively a full merits appeal?
Well, of course, so if this was a tribunal which stood fully in the shoes of the Secretary of State and could decide for itself whether deprivation was conducive to public good, then as happens in an asylum appeal or an articulate appeal, normal asylum articulate appeal before the First Tier Tribunal, once you go back into stepping into the shoes tribunal, then it doesn't really matter whether someone's had the opportunity to make representations before a decision's taken. I would accept that, absolutely. So it's a combination of the change in practice, which we've heard about today, with the Begum restrictions, that means that there is no opportunity once that decision's been taken. There is never going to be.
Well, the change of practice was a different one. That wasn't. That was not writing a minded to letter first. The absolutely bog standard thing to do. I mean, you were talking about a post-decision review, which is a bit of a halfway house. But the standard way of achieving fairness would be to write a minded to letter, and which was the practice. That was the practice which we were told to.
My Lord,
actually, no. I'm sorry. I'm confusing myself.
No.
That was also done in Lacey. I don't know whether that is normally done in these cases still. Sorry?
In section 43 cases, and you may hear more about that tomorrow, I think, but what the process is, because it's not on my
No, but in the section 42 case, which is what we're concerned with here. Yes, you're correct. Lacey was a 43 case. In a 42 case, do you know, if not Mr. McGrahy may know or know on instructions, whether it has at any time in the past been the practice to write a minded to letter? Apart from the concern which we've now heard about people renouncing their nationality, and perhaps other particular cases about very sensitive information, there was nothing about a 42, suppose, nice straightforward case where someone committed a criminal offence, a very serious criminal offence like this one. There's no particular reason other than the renunciation fear why you shouldn't write a minded to letter beforehand.
My Lord, no, I think that must
be right. Do you know whether that was the standard practice?
So my understanding, and again, we maybe, is that the use of conduciveness grounds in non-national security cases is quite new. It was being explored, and
yes,
I may know more about this, but it was being explored, and we see this in the Rochdale cases, and that it was very rare, that power was very rarely, if at all, used prior to that. And that's why the early cases about conduciveness are all SIAC cases.
All SIAC cases, yes, I see.
There's a different reason where, of course, in SIAC cases, you're not going to get anything anyway. You're not going to be given information anyway, and so there were other reasons. There were pointlessness.
Yes, I see the point. May I just ask Ms. McGrahy, do you know from your own knowledge, and clearly you were involved in the Rochdale cases, whether until this problem about renunciation came up, whether in those cases, and they may only have been rare, where you were using conduciveness in a non-national security context, it was normal practice to write a minded to letter? Was a minded to letter written to the Rochdale offenders?
I'm sorry, I cannot remember. I know that the decision letter was separate from the order, but whether there was a minded to before the decision, I cannot remember. Sorry, I can look it up.
But I can see, if you're concerned about the renunciation, a minded to letter would trigger that just as much as a decision with then a delay before deprival.
Yes, it would. But certainly 4 cases were dealt with, as Aziz being one of the first 4, in which certainly a decision letter was given with no order. I just can't, because the renunciation issue had not been thought about.
Thank you very much.
Molod, yes, I'm grateful to my friend Mr. Hodges for pointing this out. It does, the wording of the covering letter that was sent out, so the covering letter core
Yes.
bundle, page 249.
Yes.
So Mr. Kolicaj received 3 letters within 40 minutes. The first one, the first 2 arrived at the same time. The first one tells him that his status as a British citizen is under review. That's a minded 2 letter.
Sorry, that's a.
Well, that is a
Sorry, I didn't hear what you
it's a
said.
minded 2 letter. I mean,
Well, it's except that it
it was served.
except that it isn't.
Well, it looks like a minded 2 letter which has been lost its minded 2 usefulness because it was served together with the decision that the Secretary of State was minded to make. But it does look like
No. Well, it's simply a covering letter. It says, please find a letter informing you your status of as British citizenship is under review.
yeah.
When you look at it, and that is just wrong. It couldn't be because there is because well, when you read it, it's actually accompanying a 45 notice, which is notice of a decision which has been taken.
My lord, yes, absolutely. We're just wondering whether that's evidence of a template of a previous template.
That's built maybe
but it's speculative to think that.
that's speculative. Yes.
What you can so an example of
I mean, all the titles are a bit odd. It's a bit odd to describe it as under review. And notice of intention to make a deprivation order, which is what appears on the letter itself, isn't a perfect title either, because actually what the notice is of a decision, not an intention, and that is the wording of the first thing is correct. I hereby give notice that I have decided what I am intending.
My lord, yes. So that's rather similar to the wording that there used to be in deportation decisions, where when in the pre-2014 Act world, one of the statutory rights of appeal was against a decision to make a deportation order, and they had the same kind of heading to them.
I see.
And the deportation order would not, in fact, be made if you were.
Mr. Hodgetts may be right. You may be right. But again, there's a looseness of thinking about all this.
There is a looseness of thinking, and the one thing to say is there is an example here. So of the 3 documents that, the 4 documents you were handed today, the first one is the UK's present renunciation policy, and I'll come to that later. The second one is Robinson, which I'll also come to later. But the third one is an unreported case. It's the case of Kabir Hassan, and that's another of the Rochdale tranche, and that was one in which I and Ms. Bagahi appeared. That's another presidential decision, and that was a case where it's in there because it's referred to both in the grant of permission to appeal and in the decision of which you're hearing the appeal from today, the decision of Mr. Justice Dove. But that was that's a Rochdale case which was successful before the Upper Tribunal on grounds of failure to give prior notice. And so that's certainly an example of a Rochdale case where the
Paragraph 9, it seems that it was served on the 18th and on the 20th the decision was
yes,
made.
and there was no minded 2 letter. The part of the point of this case is that Mr. Hassan had no idea that he was going to be subject of any deprivation proceedings until he got the notice of intention, and then, my lord, exactly 2 days later he received the order. So it's a 2-day gap rather than a half an hour.
And
the principle is the same.
aggravated by the fact that there had been a mistaken understanding about powers beforehand.
My lord, yes, so it was aggravated, and those were obviously distinguishable features in that case. There'd been a mistake and therefore a delay in all trials.
Can I go back to ask you about fairness and the appeal? I think you suggested that if you had the FTT stepping into the shoes of the Secretary of State, then that might be another way of discharging duties of fairness. Can I just ask you, what would happen if the FTT stepping into the shoes of the Secretary of State, and therefore people adducing evidence as and when it became relevant, to the appellant, who then said, well, now that you're going to be the decision maker, today I'm going to renounce my citizenship of country A or B?
So, my lord,
So he gets no notice beforehand
Yeah.
to avoid him doing that. To ensure that there's fairness, the FTT steps into the shoes of the Secretary of State, and he then, being well advised or cynically advised, then realises that what might cause the FTT problems in the way it might have caused the Secretary of State problems, then says, now I renounce my citizenship.
My Lord, can I answer that? Can I just say one thing before I answer that? So the first thing is, just to be clear, our primary submission is still that the departure from the normal fairness requirement of giving an opportunity to make submissions beforehand has not been justified. And we say that's in itself sufficient, but we say that as a fallback, it's not justified in circumstances where there are alternative options which would not be as fair as a prior the normal opportunity to make representations before a decision is taken, but would mitigate the unfairness. So it's very much a fallback submission. And then the answer to Maura's question, I suppose, is that the Secretary of State's concern is that people stop being dual national by renounce. So the Secretary of State's concern is that if Mr. Kolicaj is told you've got 3 months to put in your submissions, and meanwhile you continue to be a dual national, and he can go to Albania and say, I'm now renouncing my nationality, and you're allowed to accept my renunciation because you're not making me stateless, or you're not allowing me to make myself stateless. So what we're recognising is that if the Secretary of State is justified in not giving prior notification, then she will renounce citizenship before the appeal starts. So through the whole of that process of appeal, as my Lord indicated, the moment that order, that deprivation order itself is self-executing. So Mr. Kolicaj, as of 11 o'clock on the date that he received the order, so I lost the 21st of January, ceased to be British. And so if this appeal had proceeded either in a non-Begum type manner, or by way of further representations and substantive reconsideration, he would have not been British for the whole of that period of time. So the Secretary of State's concern that you can use your dual nationality in order to dump your Albanian nationality wouldn't have any basis.
That's very helpful.
So he'd be in no different position from the one that he was in. So the Secretary of State's concern is that if you let people be dual nationals and give them notice that you're intending to take away their British nationality, you give them a window to become British mono-nationals, and then pursuant to, and I'll come back to that, but pursuant to section 44, you cease to be entitled to depriving of their nationality at all.
Just on the back of that, I think it would also be helpful picking up things we'd like to see if we could actually see what the deprival order looked like. I don't think we got in the bundle, have we?
My Lord, I think it's just the letter. So I think my understanding is that
we've obviously got the decision letter.
The last page.
It is here by order. It's page 6.
I didn't turn over the back page.
So that is the order.
That is the order. Yeah.
And it's.
But that wasn't. That was. Yes, I see. But that was not.
My Lord,
that was not an attachment to this letter.
No, it was sent half an hour later.
Yes,
I'm sorry. There's probably a covering letter to it which hasn't made its way into the bundle, in which we.
Just for good order's sake, I'd like to see what the whole thing looks like. But I mean, it's important in this respect that the Secretary of State has quite properly respected that this is a two-stage process. First a decision, then an order. The oddity is there's no real interval between the two. Yeah.
That's right. Well, my Lord, we can try and find, and maybe my learned friend can as well, see if we can see whether that was sent.
Yes, I see. It's got 10:38 a.m. at the bottom.
Yeah.
Okay, I'm sorry. I just afraid I hadn't turned over the back page.
I'm very sorry.
And it was served while he was still at Stamford Hill, anyway, I assume.
That's right, yes.
Yeah.
So he was in prison. Sorry, no.
And it appears that the Secretary of State has to make the decision personally, because she signed page 251.
Yeah.
But an official signs the order pursuant to her decision.
That's right. And that's well, yes, that's right. And from recollection, that's normal. So the order itself doesn't have to be signed, but the Secretary of State does have to sign off a conduciveness decision. Sorry, I'm in what was supposed to be the summary of my points, but
That's how it goes.
I
Yeah.
remember your lordship warning me once not to do that because this is what happens. So maybe I'll be quite a lot shorter when I get to the submission. So just to get to it, the third issue, which is our second respondent's notice, and what we say is that at paragraphs 53 to 54 of its judgment, the Upper Tribunal erred in rejecting Mr. Kolicaj's submission that the Secretary of State's decision was additionally unlawful by reference to what we say was unpublished policy.
Public policy point. Okay, well,
And there are two ways in which we say that's right.
I forgot I said this to you, but I do quite often say it to advocates: if you trail the point too fully, you get asked questions about it. Then, why don't we just come to the unpublished policy point when you've?
My lord, yes, I'm grateful. Thank you. So, the reason for raising the reason why I wanted to mention at the start is just to say, of course, if the court is with Mr. Kolicaj on the Secretary of State's appeal, issues 2 and 2 are strictly academic. We would say that issue 2 has wider importance, and we would invite the court, of course, depending on your lordship's view, would invite you to consider it, because the issues we've already heard that the issues about fairness and about the changes in the Secretary of State's policy do have wider bearing. By contrast, we would accept that issue 3 really does fall away because the Secretary of State has changed her published policy in any event. There's a new published policy since 2023. The outcome of a successful appeal for Mr. Kolicaj, an unsuccessful appeal for the Secretary of State, will be that the Secretary of State is reconsidering whether to deprive citizenship or not. That reconsideration wowould take place by reference to the new policy. So Mr. Kolicaj doesn't need you to consider the second respondent's notice point unless it's the only thing that he's got. So I will start by looking quickly at the legal policy framework. I'll take you very quickly through the decisions, although you've seen much of that material already, and then I'll deal with the three issues. So the legal and policy framework, it's common. There's quite a lot of common ground. It's common ground, certainly for the purposes of this appeal, that there's a two-stage decision-making process required in section 42 of the 1981 Act. That follows, we say, from the wording, which is parallel to 43. So there's a condition precedent, which is a finding of conduciveness, and that's followed by a discretionary decision. There's support from that in the approach to conduciveness decisions about deportation, where the decision about conduciveness is separate from the decision to deport. I'm not sure that I need to take. We have. You can see that perhaps most clearly from the UK Borders Act 2007, which very clearly distinguishes between the Parliament's definition. So Parliament takes away the Secretary of State's discretion completely for categories of people as to whether their deportation is conducive to the public good. And you see that from section 32(4) of the UK Borders Act. And then the discretion, the Secretary of State's discretion as to whether to make a deportation order or not is closed down to 0, and that's section 32(5), unless one of the exceptions apply. I'm not sure that I need this, given that it's common ground, but it's another example of the difference between conduciveness on the one hand and the discretion. The reason it's relevant is that I accept that, unlike section 43, where there's a very clear specific, there's a much more typical condition precedent type of matter. Has someone committed a fraud or not? It's a very clear point of fact. Has someone's committed a fraud, and that's been causative of their grant of citizenship. Here, conduciveness on the face of it, would incorporate quite a lot of discretionary judgment already. So I accept that the boundary between what is relevant to a decision about conduciveness and what's relevant to the exercise of the discretion is a lot harder to pin down.
But a hard case, and this would be true at common law, even if we didn't have to have regard to the convention, would be where it was highly conducive to remove someone's nationality because of how badly they behaved, or their associates or whatever, but doing so would have a very bad effect on their family.
Yeah.
Although if we are being strict and keeping deprivation separate from deportation, it's hard to see. It really is only the limbo period where the family might be affected. Just this.
Well, there might be rights of reunion and so on which would be affected as well. It's not.
Yes, I see.
That there might be other rights which.
Yes, I see.
Family rights
There
which
could be.
would
Yes, I see. So, but it is not impossible to conceive, or the only point I'm really making, just making sure I drop this right in my head, although there's a very big area of overlap between discretion and the condition precedent, you can imagine cases which clearly can't be brought within the condition precedent, but would be relevant discretionary considerations.
Yes, and
Yes,
so
okay, yeah.
and another example, the example which comes up here is remorse and rehabilitation, because on one view you would say that those were plainly material considerations to the condition precedent of conduciveness. If someone is entirely rehabilitated from their offending, that you might think that was relevant to the exercise, the Secretary of State's exercise of discretionary judgment as to whether it's conducive to remove them. Alternatively, you might consider that was something which would be factored in to the exercise of discretion. So
but that's an example of where the boundary's blurred, isn't it? Not.
My Lord, absolutely. So that's an example of something that could fall on either side. Sorry, yes. So it's an example of a different thing from our example, but
Yes.
That's an example which arises quite clearly in this case because you'll have seen that the Upper Tribunal wasn't satisfied that rehabilitation or lack of risk of reoffending or low risk of reoffending was relevant to the conduciveness, the condition precedent decision, but did accept that it may well be relevant to the exercise of discretion. Maybe I'll come to that later.
What is the effect of the failure to give evidence in relation to that point?
The failure to give evidence before the First Tier Tribunal, because well, the appellant was not. My understanding is there was no dispute as to the assessment by offender managers of the appellant's risk of reoffending at the time of the First Tier Tribunal's consideration of the case. What the Secretary of State's position was, I'll take you to it in a moment, but the Secretary of State's position before the First Tier Tribunal is we don't have to look at anything other than the original offending. But so there was a difference in as a matter of principle. The Secretary of State said in order to assess future, insofar as it's relevant at all, consider risk of reoffending. Then all we need to do is look at the previous offence, the facts of the offence. We don't have to look at any more recent assessment. I don't understand.
I mean, if one looks at, I mean, if you were saying this is an important point in looking at discretion, and it's just so you can deal with it. But if one looks at rehabilitation and all the rest of it, the fact that you put in a note suggesting that you had nothing to do with it, reverting to your Newton hearing, and then abandon it at the FTT rather suggests you're still on the journey rather than have arrived at the destination of true remorse and rehabilitation.
Well, it depends what that note said and the extent to which.
Well, we've got what the FTT say about it. That's all, and it was ready to give you an opportunity to deal with it.
Yes, well, I'll come back to that, but my Lord, first, it doesn't necessarily suggest that, and that's not the basis on which the First Tier Tribunal approached the evidence. It doesn't. So risk of reoffending doesn't automatically depend upon acceptance of previous of all of the details of previous offending. And then this is a case where there were obviously potentially, but my lord, I would have to remind myself of the contents of that material which was before the First Tier Tribunal. I don't have it. I'm not sure whether I've seen it yet. But we don't understand that to have been the basis on which either the Upper Tribunal or the First Tier Tribunal approached risk of reoffending.
Thank you.
But can I show you? I'll show you when we get to it what the submissions were that were made before the First Tier Tribunal and why we say that doesn't that wouldn't matter. But anyway, again, I was at the point of saying that it's common ground that there is a distinction between the condition precedent and the exercise of the discretion. It's not necessarily common ground what belongs where, but yeah. we accept that it's common ground that both decisions have to be taken. What are the protections which are in place for someone who is the subject of a decision under Section 42? First protection is that the Convention and now policy that such decisions are only taken by the Secretary of State in person. So the Cartona principle is disapplied. That is indicative of the seriousness of the decision which is being taken. But it's relevant because it means that any review must be conducted by the Secretary of State as well, and it means that it's the Secretary of State who must have seen and had regard to material which is said to have been taken into account in the decision-making process. That's one significant protection. Other protections are that the completely separate protection against statelessness in Section 44, and we say that's because that's not the fact that's not a. So the exercise of determining whether you're going to make someone stateless is not a part of the discretion under Section 42. It's a separate exercise because it creates a blanket ban on the deprivation of citizenship of certain categories of people. The third protection, so there's the protection of the disapplication of the Cartona principle, the protection against statelessness. Third protection is the right of appeal to the First Tier Tribunal, to SIAC. And the fourth protection is the one...
You say to the First Tier Tribunal or SIAC, yes.
Or SIAC, yes, depending on whether classified as being relied on. And then the fourth protection are the provisions of Section 45, the notice which has to give you your reasons. Of course, we say that the reasons must be sufficient to understand why the Secretary of State has decided that it's conducive to it's conducive to public good to deprive you of your citizenship, and also why the Secretary of State has decided, or at least showing that the Secretary of State has had a discretion.
Yes, 45 was introduced. Originally, there was no right of appeal. Is that right? You had to judicially review if we go far enough. When the 1981 Act first came in, is that right? Oh, I'm confusing myself. The right of appeal only came in
Well, I'm afraid I'm
2002.
afraid I don't know the answer to that. I'm not sure. I think that you may be getting a history of appeal rights in relation to the appeal tomorrow. Just from
I saw a note just before
yes,
we came in.
I think you may.
It looked exciting to read, but I didn't have enough time.
Well, I'm sorry. So maybe. Well, I should probably read it as well. But I think that Ms. Nike has prepared a note for tomorrow's appeal, which goes through the history of just from an email exchange I had with her earlier in the week, that I think she was intending to do that.
Well, it certainly arrived, but I'm afraid I haven't read it yet.
No, I'm sorry, and I'm afraid I
Okay,
don't know the answer to that.
don't worry. Yes, but well, I suppose what I was interested in just establishing is the purpose of 45. Is entirely to make possible the right of appeal,
Yes.
which was introduced at the same time.
Yes. So My lords, I will look this up. It should be possible to look this up during the lunch break and find out what the history is of the introduction of that. Because
Okay,
I
well,
think
the history was perhaps a bit of a red herring. I just wanted to clear my. But certainly, the Act as it is now, the purpose
function,
of 45
yes, exactly.
is the function of 45 is ancillary to the right of appeal, or to make the right of appeal real. Because you've got something to appeal against, and you've got to and you can see the reasons.
You've seen the reasons
and you've been told that you have a right of appeal. Yeah,
my lord, exactly. So so we say that the once given that function within the statutory framework, then the clear intention is that the reasons are sufficient in order to.
yeah.
to
Because
enable
sorry to
it.
make the only point of splitting out the decision, the appealable decision, and the order would be to allow an appeal in between the two of them, because otherwise, surely you just make the order, and the order would obviously have reasons in the usual way. But I can't see any other purpose for having a decision and an order as separate creatures than to give you something to appeal against before the I was about to say before the order is made, but perhaps this train of thought is going further than I intended.
Well, my lord, I think that my own friend may have indicated that the consequences of removing the gap, of removing the provision that you recorded or the practice that you recorded in ATSI, which was to defer making a deprivation decision until the lawfulness of that decision had been determined by the tribunal. That's the reality of it. The consequences of removing that practice and changing that practice may not have been properly thought through, and as my lord indicated, it may well be that legislation could have sorted out the consequences of this to some degree, but certainly what we'd say is the change of practice, Secretary of State's change of practice doesn't change the function of this provision in context as it was enacted, which is that you have before. That in a meaningful way you're able to go and appeal, and you know that the Secretary of State's reasons, so that you can take a decision whether there's any merit to the appeal, what your grounds of appeal are going to be, what evidence you need to adduce, and so on. You can conduct a meaningful appeal. So and then my next note was to address the question: what does conducive to the public good mean? It's a phrase that's not defined further at all, as you know, in the Act. We can work something out from the meaning of the word conducive to the public good, but beyond that, there's not much help from the Act. The policy, which was the published policy, which was in place at the time of the decision, is the one at tab 4 of the authorities bundle, and the only guidance. So so there is the absolutely wide-ranging power given under the Act. Then that power is limited in the policy. So it's page 35 of the authorities bundle. And
55.4.4.
Yeah, so conduciveness to the public good. Well, it's rather strangely drafted, but it means something is conducive to the public good if there is a public interest in depriving on the grounds of involvement in terrorism, espionage, serious organised crime, war crimes, or unacceptable behaviour. It's very widely drawn, particularly with the inclusion of unacceptable behaviours.
Yes, somewhat perhaps rather pathetic.
It is slightly pathetic,
especially
could be all kinds of things.
Well, it's certainly, I'm not sure. It depends on the Secretary of State, doesn't it? What's unacceptable
Well,
to anyone?
perhaps it does. But
no.
What is the status of this definition here?
So the status is it's the only published indication of the way in which the Secretary of State will exercise her first discretionary judgment as to whether it's conducive to the public good, and secondly, discretion beyond that discretionary judgment as to whether to make an order. That was the only published guidance as to how Section 42 would be applied.
Because you've submitted that there's a difference between you and Ms. McGahey about the scope of what conducive to public good includes. It could include lots of things if you just read the statute, but if you look at this definition, it means a lot less. It just means whether you've been involved in espionage, etc., or unacceptable behaviours.
But it doesn't say, for instance, whether it's ongoing involvement or past involvement. It doesn't say whether it's and it doesn't say, and obviously it doesn't say anything at all about the level of the involvement or the evidence which is needed to prove. I'm not criticising the policy for that. I'm just making clear that that's a policy which is deliberately, in my submission, it's deliberately intended to give the Secretary of State to leave the discretion as wide open as possible. And as my Lord says, the slightly pathetic. But in any event, plainly it's a mop-up provision at the end, and it gives the Secretary of State a very wide, a very wide discretion as to, on the face of it, as to what might be conducive. So if my Lord's right, and what this an involvement means, involvement and nothing more, with no recognition, no need to consider future. I'm not sure whether that's what my Lord was saying, but if that's one way of reading it,
looking at it,
it's one way of looking at this would be you tick the box of has been involved in these things and that's enough. In that case, then the question of whether there's a risk of you doing it again, what danger you would pose if you did do it again, those would all, in my submission, they would become obvious, relevant considerations in the exercise of the discretion, if not mandatory ones, certainly obvious ones. So the more narrowly you draw the line around the test of conduciveness, the more you're going to have to consider at the time of the exercise of discretion. I suppose that's our point. So if the actual risk that so we just straightforwardly, the exercise of the discretion under Section 42 must include a consideration of the risk that a person poses. We say poses to the community of the United Kingdom if they continue to be British citizens. That may not be determinative, and I'll come back to that when I look at PAM. But it must.
So
be
can I just have the submission again? It must include.
So it must. It must be. I don't want to overstate. So it must be a relevant consideration to a decision whether to exercise the 42 discretion that a person does or does not pose a risk to the community of the UK. Now, I'll come on to say we accept it's not a mandatory precondition. There's an example of that in the case of PAM. We accept that it's not a mandatory precondition, but as a consideration, we say must be a relevant one, or at the very least, there's a presumption of relevance. I'll come to that.
Yes, I mean the case where it might come up is someone who's committed war crimes abroad. Yeah, and it only becomes apparent after they've been here a long time and acquired British citizenship. And deprival then would be, the Secretary of State could say, I don't care, you won't have an opportunity to butcher thousands of people in whatever you did in some foreign country anymore. Yeah. But a person with your record is not someone we wish to have as a British citizen.
My Lord, absolutely, and that's quite close to the PAM case. Yeah. But an example of a case where it would be relevant, we say is a case like the present, where a part of the Secretary of State's argument is that allowing people to retain dual nationality makes it easy for them to travel backwards and forwards. It's part of the operational it's part of the operation of money laundering gangs and the movement of money between countries, and the usefulness, the Secretary of State might say, of a person who is a dual national is that they can go in and out of Albania and the UK without having their passports checked, without having to get visas and so on. and you'll see that that is part of the Secretary of State's reasoning in cases like this. And in those circumstances, so in a case where the offence itself is not the slaughter of thousands of people in a terrorist act, it's a lower level, still serious, but a lower level act like money laundering, conspiracy to money laundering. And in those circumstances, we would say that if there was no risk of a person doing it again, then that would be relevant, that would be presumptively relevant to a decision, firstly, whether it's conducive to public good at all, and secondly, in any event, whether the discretion should be exercised in favour of the deprivation order or not. And so the more narrowly drawn, and the only point I was trying to make at this stage was the more narrowly drawn the definition of conduciveness is, the more likely it is that other factors will have to be considered at the time of state of the exercise of discretion without necessarily being prescriptive about what those things are. But what I wanted to do at this point was simply to compare that with the ministerial submission from May 2020. Because we say that on any view that ministerial submission restricts so if I can take you to that, sorry, to in the main bundle, the core bundle at page 146. This is the Fiona Johnson submission, and it's very heavily reacted. We don't take any issue with the redaction. But what we see here is a submission to the minister that we should use the deprivation power against people of serious organised crime, but limit its use to the most serious and high-profile cases. It's not talking about terrorism or war crimes and so on. It's talking specifically about serious organised crime, the most serious and high-profile cases. And then there are explanations for the reasons for this. There's a bit about the history of it, which relates to what Mullin and Friends said. That's on page 147, paragraph 2. So there's been testing the exercise of the power from 2015 onward. Paragraph 4.
Just one moment.
Sorry, yes.
Yes, so what we infer from that, which I think is very much what Ms. McGarhy told us, is that until the Rochdale cases, it hadn't in practice been used for
Serious organised crime.
serious organised crime.
For non-psych, and we say for non-psych cases, this is why this has arisen more recently. But so what we say is new by comparison with the published policy is the limiting of the use of the most serious and high-profile cases. A recognition that this is a power which has to be used restrictively. My Lord, on page 147, paragraph 4, you see the recognition of the fact that deprivation may be used in circumstances where deportation is unlikely.
So where's this at?
Page 147, paragraph 4.
Yes.
So there may be other reasons why the Secretary of State might consider it abusive to the public good to deprive of citizenship. You make people more, you make someone more precarious.
Yeah, so it doesn't explicitly make the point, but it also sends some sort of emotional signal about, or made some moral judgment about entitlement to be a British citizen. It's rather more narrowly to do with losing benefits such as passport facilities.
Yeah, so there's no reference here to expressions of public
expression, the word we're not allow us to use, revulsion.
Revulsion, no, well he didn't, but it's interesting that there isn't. I'm not going to. I think we've agreed that we're not going to try and take you through the First Tier Tribunal decision at any length, but the First Tier Tribunal certainly thought that might be one of the reasons for doing this, and it's not part of the reasoning here. And what this ministerial submission says again in paragraph 6, we consider it's an important part of our toolkit. It says in tackling serious organised crime, but only in the most serious and high-profile cases, used sparingly. That's on paragraph 6 on the bottom of page 147, and then top of 148, paragraph 7, to mitigate the risks of expanding the use of deprivation to expanding the use of deprivation to serious organised crime cases. We recognise focusing the policy on the highest harm offences. We expect the number of serious criminality cases meeting the threshold for deprivation to be very low. Focus will be given to organised crime, particularly that involving violence, sexual and other high harm offences such as trafficking, organised drug importation and child exploitation. It's not a fettering policy, but it is a policy which gives an indication of of the kinds of cases that the Secretary of State is likely. So first, the highest harm, and secondly, categories which are particularly likely to be the subject of this decision making. So it's a discretionary policy. It regulates the exercise of discretion, doesn't fetter it. And I'm not going to bring you back to this unless necessary. When I come on to issue 3, I'm going to be saying that these are the kinds of things that a person would and should be able to address. So if a person is going to have a meaningful opportunity to make submissions to the Secretary of State about whether they should be deprived of their citizenship, they should be able to address this kind of category. I don't fall into these categories. I'm not the highest harm. I'm not the highest profile, and so on. And there's certainly more to address in a letter making submissions as to why a discretion shouldn't be exercised in favour of deprivation. There's more to address in this letter than there would be in the policy that I showed, the published policy that I showed you before.
And can I just check for your third ground, which is the secret policy? Is this the whole of this, what you say is the secret policy?
Well, it's what's been disclosed.
Yeah.
Yes.
Thank you.
My Lord, I wouldn't wish my submission to depend upon whether this is a policy or an accepted practice or improved. This is what the Secretary of State says. This is the way in which the Secretary of State is invited to exercise a discretion, and it's common ground. The Secretary of State agreed and proved this as a practice. I can show
Was there any witness statement disclosing it?
I was going to take you in a minute through the way in which this material. Yeah, no, it's because I keep slowing myself down. Can I just say that there were 2 other things while I was in law, and then I'll take you quickly through the order in which things came out, how they were disclosed. So, just on the point of whether risk of reoffending is relevant or not, and just to make clear what our position is, in the case of PAM, which is in the authorities bundle at tab 11, and the Secretary of State has relied on this case. But just to clarify, Mr. Pam was one of the issues that arose. So I'm on page 309 of the bundle, starting to read paragraph 52.
Hang on 1 second. Yeah.
Is a risk of reoffending or risk of harm in the future a precondition for the exercise of the section 42 discretion? We accept it's not. So it's possible in a case like it was all rather theoretical with Mr. Pam because he was serving a 40-year prison sentence overseas, but it was not necessary in a case like this to consider whether a person posed a risk. His argument was, because I'm serving a prison sentence for 40 years overseas, I don't pose any risk at all, and therefore you can't exercise your section 42 discretion. And there were other reasons why that submission wasn't accepted, but one of the points that the Court of Appeal determined here, Lady Justice Arden, as she was, is that that section 42 does not specify and would have to specify a risk of future offending if that was in fact a precondition for the exercise of that discretion. So we accept that. But what we don't accept is that it follows from that risk of reoffending is irrelevant. So we accept it's not a mandatory precondition, but we don't accept it's irrelevant. And it is helpful to look at where the discussion goes after paragraph 52. And I accept that that's what's said, and looking at paragraphs 54 to 56, I accept they're not directly applicable, or some of what's said here is not directly applicable because we're not in the territory of EU law anymore, but it's very clear that, that the court in PAM derived its approach from the approach in EU law, and particularly relevant is the reference to Robinson in paragraph 56 and to Bouchereau, where in Bouchereau the European Court of Justice had held that it's possible that, so I'm in the quoted paragraph 29 alongside letter F, it's possible that past conduct alone may constitute such a threat, i.e. a present threat, to the requirements of public policy. But the reason we've handed up Robinson as well today, and that's now in tab 20, it's in the little supplementary bundle we have today. This is my Lord Justice Underhill will remember this because you're on this panel, but this is judgment of Lord Justice Singh. And so this court in Robinson approved the principle that past conduct alone can in certain contexts justify a deportation order under EU law. This was an EU law case. But then Lord Justice Singh goes on to say, paragraph 85, cases where past conduct alone are potentially sufficient are cases whose facts are very extreme, and examples are kinds of cases where someone has committed grave offences of sexual abuse or violence against young children. Another example in paragraph 86 of a very serious offence. It's the case of Marchon, which is a UK case where a doctor had imported 4.5 kilos of heroin and got 11 years imprisonment, and there was particular emphasis on the breach of trust of the doctor importing heroin. The important thing there, I'm not trying to draw any kind of hard line parallel between the situation or the situation under EU law and the approach to conduciveness under section 42, but just indicating that that was the example that the Court of Appeal itself referred to in PAM, and PAM is a conduciveness case. And all the principle I'd want to derive from that is that there is a presumption that future risk is relevant to an assessment of conduciveness. The Secretary of State may well, having considered the facts of the case, decide that past conduct is so extreme that by committing that past conduct, the person has lost the right to be treated as a British citizen. And that's what PAM recognises. But we say that in the majority of cases, at the very least, that process has to be gone through, and a risk or absence of risk of reoffending must be taken into account at some stage in the conduciveness, either the conduciveness decision or the discretion. And then the final
just
point
mention for completeness, I think given the nature of your submission, it won't be necessary for us to look at, but I just want to tell you, in case you want to double check, there has been a much more recent Bouchereau decision of this court. I didn't do the judgment, but I was on it.
It's with specific reference to the 10-year protection, isn't it?
I honestly can't remember, and I don't want to spend any time on it, but I just thought, since you'd referred to this line of authority, you ought to know there is a further case in
My,
it.
my lord, I'm familiar with it. I think that it was about the
Well, unless you want to say that it reinforces the point you already made, which I wouldn't have thought it did.
No.
We didn't say any more about it. I just didn't want you to have overlooked it because it's very recent.
No, my lord, no, I'm familiar
Okay.
with it. I don't think it either reinforces.
It's
My recollection is it's very specifically in the context of this person who's acquired the highest level of protection.
I think that is right. Yeah. Okay.
My lord, so the final thing was just to clarify our position on the Begum point, and that's we watched the hearing from last week, and we heard Ms. Smythe very helpfully clarifying that that we weren't going to be running a challenge to, in this case, to the applicability of Begum, and also heard my lord's the point that my lord raised about where exactly the line around Begum would be drawn, just a query, and whether there should be a distinction between, on one view, there might be a distinction between national security cases and organised crime cases within Section 42 on grounds of institutional competence, and that specific subset of so that of the three factors in the Raymond case which justified the Begum approach. There was the institutional competence point, the democratic accountability point, and the separation of powers point. And you might think that on the question of institutional competence, the courts are just as competent as the Secretary of State to examine issues relating to serious organised crime. On the issue of separation of powers, you might think that the more that an issue relates to the conduct of an individual or a decision taken about an individual, the more likely it is that falls within the scope of the court. We make no submissions about any of this. It's our understanding, I think Mr. Blundell may have said this as well, he's in cases which are on appeal from SIAC where this specific question will be considered. The position before the Upper Tribunal and the First Tier Tribunal, Mr. Kolicaj's position was that both the Upper Tribunal and SIAC have decided, the Upper Tribunal in Chimi and Chicheri has effectively decided that Begum applies across the board to Section 42 and Section 43 cases, and no doubt you're hearing submissions about that in the two other cases which you're hearing. SIAC has decided in a series of cases that the Begum approach applies in serious organised crime cases. Those are the cases which are on appeal to this court in May. We've reserved our position, but very gently reserved our position on this because we don't have strong submissions to make about the Begum approach not applying. The two issues that would follow from the Begum approach are then, in what circumstances should the tribunal be making any findings of fact?
Sorry, just to be clear about it, if that's a formal say, you're reserving your position.
Well, no,
Outcome of a case in May. I mean, we will have decided this case by then.
No, yes, you will. So we're not. So
you're not taking it.
We're not taking any point on this. So we're not reserving our position,
well,
pending any judgment at all. No, we're just saying that if there is one version of the Supreme Court's decision in U3 and the decisions of this court in this court in May, which would require some rethinking to be done about the approach that the First Tier Tribunal took in this case. We're not trying to run this point. We're not asking you to.
Okay, well, fine. So you're not, but you said that. So assuming that Begum, as it has so far been construed, applies, that has two consequences.
That has two consequences. One, the first consequence is that there is a very limited fact-finding jurisdiction. There was a very limited fact-finding jurisdiction for the tribunal, other than in Article 8 cases. And this is not the case where it was thought, it's certainly not a case where it was submitted to the First Tier Tribunal that there were significant factual differences which required to be determined. So significant, that it was not a case in which the First Tier Tribunal was invited to make findings of fact. And certainly it's not our submission on the law as it currently stands, and having regard to the wording of Section 42, that any tribunal is going to be stepping into the shoes of the secretary for itself, whether the deportation of a person is conducive to the deprivation of person citizenship is conducive to the public good. We can't run that submission. That's why we're not trying. So that's not, it's not a submission that's been made at any point in this case. That's right. Yeah. So that's why we're not. I don't feel that there's any possibility in reviving that, and we're not reserving our position pending anything. If there is some sort of windfall from a different judgment, so yeah.
Unless it was the only way to meet your point about notice being given.
So, my lord, exactly. So we make our submissions about fairness in the presumption that Begum is correctly decided, and is, of course, Begum is correctly decided, but that it's correctly applicable to this kind of procedure. So that's from. Sorry, I shouldn't have used the term reserving. I suppose we await with interest the outcome. That's not reserving, is it? But we're reserving our interest in what the courts are going to do with it. The other point is the consequences for Article 8. We haven't sought to revive a freestanding Article 8 ground here. As you've indicated, my lord, the approach to Article 8 in citizenship cases is different from that in deportation cases, with the consequence that it's only if arbitrariness can be shown that Article 8 is engaged. And that's Lord Reed in Begum, following cases like K3 and Usmanov in Strasbourg. And in a case like the present, in order for us to show arbitrariness, we will be succeeding on one of our public law grounds. Article 8 adds nothing to the picture. There is a...
And then sorry, what were you about to say?
There's a real difficulty in the guidance which is given, particularly in Chime. I don't think I should be addressing you on that. It's very difficult.
Mr. You're so steeped in all this, and impressively steeped in all this, that you can't resist floating points that you're not taking. But if you're not taking it,
I'm wasting.
I think it'd be easier for us just not to.
Yes, I'll stop doing that. So I'm not taking. I'll not tell you anything more about any points that I'm not taking. So the chronology. Mr. Kolicaj entered the UK in 2005. He was naturalised in 2009. He married an Albanian national in 2013. He was convicted in 2000, and he'd become British when he was already British. The children were British. He was convicted in 2019. And he was in prison until about February, we think, 2021. While he was still in prison, he was served the notices that you've seen. The point to make there and about those is that nothing was served with them at all. So none of the annexes, and you have this point already, my lords, none of the annexes which have subsequently emerged were served, nor is there any reference to them. So this isn't. There is no.
Well, not just the annexes, but not the ministerial decision either.
So not the ministerial.
So he gets the decision, but he doesn't get the ministerial submission.
Doesn't get the ministerial submission. Doesn't get at that stage the NCA recommendation. Doesn't get any of the assessments. So it doesn't get any of the annexes at all. And then these documents sort of emerge gradually in the respondents bundle. So the respondents bundle, which was so Mr. Kolicaj appealed relatively early in the appeal procedure before the First Tier Tribunal. The Secretary of State discloses the NCA letter. I think that's Annex A to the ministerial submission, but anyway, it's separate. So that's the original NCA letter. You have it at pages 34.
Saw it just now. Do you need to go back to it? Yep.
No, you don't need to go back to it. It's at pages 34 to 36 of the
Bundle.
Supplementary bundle.
Side of 22.
It doesn't include any up-to-date assessment of risk of reoffending. It derives assessment of risk from the nature of the offence, of which the
Yes, there's an interval, isn't there, of how long between the recommendation and the ministerial submission and the ministerial decision?
So
This is October 2020, and the decision.
My lord, yes. So the NCA recommendation is from the national. So the recommendation from the National Crime Agency is 19th of November 2020. The ministerial recommendation is from December 2000, the 17th of December 2020. And then the decision itself is in.
Oh, I see. It's not such a big gap as I remembered.
No, it's not very long.
Can,
Gap.
can I just ask you about your submission that you've just made, which it doesn't deal with future behaviour or future risk?
So it bases its assessment of future risk on past conduct only. It doesn't include. So that was the point, my lord, which I was making to you before, that what the NCA does is looks at the type of offending in which the type of offence in which Mr. Kolicaj was involved,
yeah,
and its context, and derives an assessment of future risk, but it doesn't include. So it doesn't refer to all the documents that we're used to seeing, OASIS reports, probation assessments, and so on. It's a pure. It's the most bare actuarial process of assessing future risk on the basis of past conduct.
All assessments of future risk have strengths and weaknesses, but this seems to be sort of solidly based on the fact that he went after the arrest of two of the couriers, and then went to Albania after the arrest.
So it's based on the fact that he continued in the face of warning, but he didn't stop. But also, so it's based on past conduct.
And experience shows, or sometimes shows, that OASIS reports and assessments really not more valuable than common sense from a criminal point of view.
My lord, if you were a First Tier Tribunal, I could make submissions to you on those facts. But our point is that those submissions haven't been made and they've not been considered, of course, by the First Tier. Of course, that's right. I'm not suggesting there's any magic about OASIS assessment, but they are a competent assessment by an organisation which is intended to assess future risk.
We have just what's the date of the OASIS material which you're referring to? Was it done while he was before his release?
It was done immediately after his release.
Immediately after his release.
Can I take you to it in a moment? I was just
okay. No, of course.
So just while we're on this page, then 35, because this is where this is the reference to the importance of dual nationals to this kind of operation. So you see that on the bottom of page, towards the bottom of page 35, the physical conveying of criminal. So according to the NCA, senior figures remain in Albania, and getting the money to and from Albania is important, and therefore dual nationals are useful. So the Secretary of State, we accept the Secretary of State's justification here for the exercise of her discretion could in principle include the usefulness in taking away people's ability to travel across borders without control. But then over the page, and this is what my lord was referring to, determination, past determination. So top of page 36, there's a single factor which gives rise to an assessment of risk. Determination to carry on misbehaving, that shows that they will continue to pose a risk following completion of their sentences. So on the face of it, the NCA is saying that future risk is a relevant consideration to the exercise of discretion, not suggesting that that's an irrelevance. And then there's continuing presence in the United Kingdom is clearly not conducive to public, but of course that's a deportation consideration in reality, although we accept that deprivation is the precondition for deportation. So that's the first document. That's the NCA's recommendation from 19th of October 2020, and that was disclosed. I was trying to go through these in the order in which we obtained
Yes, okay, we've got that. That was disclosed. Where are we going next?
So the next one then was that the Mr. Kolicaj's solicitors made a series of applications for disclosure, and those resulted in the ministerial submission being provided, and that wasn't provided until the 18th of February 2022, so over a year after the decision had been taken. And so you've been taken to the ministerial submission. I don't propose to take you back there again. The submission itself is also on page 17 of the consolidated bundle. But the covering letter to that is at pages 14 to 16 of the supplementary bundle. That's the letter by which it was disclosed to Mr. Kolicaj. And you see from that letter on page 14 of the supplementary bundle that the Secretary of State didn't think that this was necessary. It was necessary to disclose this material. Makes submissions about duty of candour. And then provides the ministerial submission and annexes. She also says...
Well, there's the remaining annexes.
Yes, the remaining annexes. Sorry, yes, of course, that we already had, or Mr. Kolicaj already had the first one.
Yep.
But you see that this is provided in a spirit of cooperation.
But you're taking this very elaborately. I mean, you may feel aggrieved that all this was disclosed late, but is there a point relevant to what we have to decide?
So two things. One, that it wasn't before the Mr. Kolicaj for over a year.
So what?
The time doesn't matter. The point is simply that it was never intended to be read as part of the decision.
Okay.
And it was only the Secretary of State didn't consider that it was necessary to disclose it. Okay,
but it obviously wasn't intended to be read as part of the decision because it was never sent at the time.
No, but it wasn't even provided with the respondent's bundle. So when the respondent decided what she thought needed to be provided.
Okay, I don't want to miss an important point, but I don't want you just to make complaints about. The basic point is it wasn't part of the decision. And what are you adding to that?
The Secretary of State didn't think it was part of the decision.
Yes.
That's it. So the Secretary of State at least could say about the NCA decision that once an appeal had been lodged, she served and she thought she had to. But this, she didn't think she had to. She served it only as in a spirit of cooperation. She also says, "My Lord, I'm not trying to complain about anything. I'm sure I've said all I need about this." Paragraph 5, the 5th paragraph on there, in response to that request, chapter 55 and so on, we confirm there is no other guidance, published or unpublished, which addresses how Secretary of State should exercise the deprivation power under Section 42. We'd say that's at the outer limits of not misleading. Just because what wasn't disclosed at that point was the general ministerial submission. Further correspondence was necessary. So you'll see on page 24 further correspondence, and at that point the ministerial submission is
the earlier ministerial submission.
The earlier ministerial, so the general ministerial submission, which we say as a policy in any event is a statement, a written statement of accepted
When was
practice.
that produced?
So that was produced to us under cover of the letter of the 23rd of March 2022, of the supplementary bundle. And again,
Sorry, which page of the bundle?
Manuel, sorry, it's page 25 of the
Thank
supplementary
you.
bundle. That's the covering letter in response to an email reply.
Thank you very much.
Sorry, I probably laboured this for far too long. The only points we're making are that policy really it was not being disclosed, and that the various documents which the Secretary of State says should be read as being part of the decision were not treated as being part of the decision. The appeal proceeds. It's relevant just quickly to look at the Secretary of State skeleton argument before the First Tier Tribunal. That's in the supplementary bundle, starting on page 57. And the Secretary of State's position at that time on risk of reoffending is on pages 67 and 68 of the bundle. So, Secretary of State relies on PAM. It says not required. We don't require there to be a risk of reoffending. The policy test is involvement in serious organised crime. Well, that may be the case.
Sorry, where are we reading? I've got what page?
So
what page?
page 67, paragraph 39, bottom of the page, first sentence.
Thank
First
you.
sentence.
Yep.
So that's, and then paragraph 41, insofar as the risk of harm reoffending is relevant, the Secretary of State is obviously entitled simply to look to the index offence, as she did in this case. Well, that must be a reference to the NCA's, what would seem to be a reference to the and then at paragraph 42, towards the bottom of paragraph 42, the Secretary of State is not required to look beyond a conviction. So the Secretary of State's position there is, I'm not required to do this, but insofar as I did, I'm not required to consider risk of future offending at all, but insofar as I was, I'm entitled simply to look at the previous offence. I don't have to look at the conviction, I don't have to look at anything else. My Lord, in the course of that appeal, the risk assessment relating to the appellant, or to Mr. Kolicaj's reviews, that's in the supplementary bundle, starting on page 37. Good compliance with probation services, and then you have the assessment. And these are assessments which have...
Sorry, which page? Here it is.
39.
Page 39.
Yeah.
Okay, did you refer to page 37 or did I know?
37 is the covering letter, which
Yes,
just
I see.
shows.
Okay,
So
got
it
it.
shows,
Right, yes, sir.
yeah. So it's probation saying good compliance with probation, and then you have the assessment here. And page 55 explains what a risk and needs assessment
Sorry, and what's the date of this?
So it's served, it's dated the 24th of March 2021.
24th of March.
2021, so it's quite shortly after his release.
Okay.
And it's low risks of reoffending.
Yep.
References to the very low amount of money which Mr. Kolicaj himself obtained from this criminality. That's on page 42. And references to the financial difficulties that he was in at the time of the offending, references to remorse. And on page 48 that he was using food vouchers, the children were known to social care. So the references to reduced risk of reoffending, the circumstances in which the offence were committed, not incompatible with disputing some of the edges of the facts, if that's what Mr. Kolicaj did, but an assessment nonetheless of a low offending limit. The matter came before the First Tier Tribunal. You have the First Tier Tribunal's determination. You have it 3 times actually in the core bundle. We'd agreed that if we were going to refer to it, we'd refer to the version which starts on page 123 of the core bundle. But unless I need to, I wasn't going to take you into that. Sorry, having just said that, just in response to what my lord said, on page 130, paragraph 30, you see that the tribunal was not invited to make findings of fact, and so no disputed issues of fact, and so no evidence was called.
Can I just ask you this, because you've taken us through the Oasis material,
Yeah.
and we've obviously got Judge Kent's sentencing remarks. I mean, the judge's assessment does seem to be completely different from the Oasis material, which is, I only got £1,000, I had financial problems, I'm very sorry about it, etc. Judge Kent, you were the ones organising and you controlled the couriers.
Well, that's not, but those aren't inconsistent. I don't understand it to be in any way disputed by the appellant that's correct. That's not the basis upon which this case is being run or was being run. I think in the first tiers. The question is whether he was getting money from it.
Well, what was he doing it for if he wasn't?
Well, for £1,000 if he desperately needed it, and maybe paying off debts, but he wasn't getting money from. I'm not.
Because one reason why, when you go to the criminal courts and judges express scepticism sometimes about Oasis reports, is because they can make an assessment of dangerousness or future risk of harm to others, etc., for themselves, and are not bound by Oasis reports. And looking at that, I hope not unfairly, it does seem to be full of minimalist behaviour, and he didn't go and give evidence to the FTT about it.
Well, but he wasn't. But the FTT was not going to have regard to this in any event. And the FTT makes clear that it wasn't willing to consider the Oasis report. So he wasn't going to be asked. So because of the approach of the Secretary of State, because none of this material had been before the Secretary of State at the date of decision, my lord, I hadn't anticipated this question. It may be that I'm not going to be finished before lunch. No, I'm able to take you more effectively to this
Of course, yeah.
Quickly after lunch. But my lord, but again, my first answer on this will be that these would have been submissions that could have been made. Firstly, if the First Tier Tribunal had, firstly, they're submissions that would have been made to the Secretary of State and considered by the Secretary of State if Mr. Kolicaj had the opportunity to make them. Secondly, they'd have been at least considered by the First Tier Tribunal if it had admitted this material. And thirdly, it would have been, findings of fact about it could have been made if the tribunal had the jurisdiction to do so, which on the present law it didn't have. So it's in those circumstances there wasn't any point calling someone to give evidence where their evidence couldn't lead to any findings of fact in any event. But my lord, I'm not trying to make submissions to you about the weight that should or should not have been attached to this Oasis report. It was there, it was not disputed. It wasn't disputed probably because it wasn't being considered.
You were going on about future risk, and all I was doing was pointing out that there was some material that might indicate future risk regardless of the Oasis report.
My lord, well, I'm not. I'm sorry if I was going on about it, but I wasn't. I'm not suggesting that there was only one possible view of future risk. I'm suggesting there was material which should have been considered and by both the Secretary of State and by the tribunal on appeal.
You're basically anticipating an answer, which I don't know whether you would have got, to the effect of there was nothing useful that could have been said if he had been given the opportunity to make representations.
My lord, absolutely yes, because that's. Oh, sorry, I'm anticipating that answer. No, sorry,
I'm trying to understand what all this is going to, because it doesn't appear to be directly relevant to any of the submissions of law that you're about. You haven't got your submissions yet, but you're taking us through various pieces of material and making observations on them as you go through, which is a perfectly okay way of doing it. But I just want to make sure what it actually goes to in the submissions you'll be making this afternoon.
So
none of your grounds of appeal are about the risk of future.
So I understood his lordship to be inviting me to respond to a submission or to respond to a possible view that the Oasis report would have made no difference. If I've
that was
misunderstood.
Because you were taking us through Oasis report, emphasising that it all relates to future risk and asserting on the basis, as I understood it, or perhaps I misunderstood it, on the basis of the Oasis report, that this man posed no future risk.
No, well, so I wasn't making an assertion that he posed no future risk. I was asserting that there was evidence that he posed. There was evidence from on the face of it,
an Oasis report which seems to have been based on his self-reporting.
Well, my lord, so I'm being drawn into submissions about the
You're
substance. of the
drawing
Oasis.
yourself into them, that's the point.
Because you're taking us through this material. If it's not relevant, don't take us through it.
So, my lords, I've been asked about the substance of it and about where it is. So I've taken you to it in response to your questions. My submission on it is that there was material before the First Tier Tribunal. There was material which would have been available to the Secretary of State if she had sought it, and there was material before the First Tier Tribunal that was not considered, and I was taking you to it. I'm not making a submission as to the findings that would have been made by a tribunal which had the jurisdiction to make findings about this, or to consider it, to compare it with other material, to hear potential explanations for it, because I can't make those submissions. That hearing
Yeah,
didn't
well,
take
I understand
place.
that, but I'm just trying to see how that fits into your grounds to the issues on this appeal. One is about is the appeal itself, to which none of this seems to me to be material, or is it?
So my lord, it's part of our case, and I think this is why my lord asked the question to start with. That it's part of our case that one of the factors that needed to be considered, and this is all I think I'd said initially, was that one of the factors that needed to be considered by a Secretary of State rationally making a Section 42 decision is risk of reoffending.
Yes, I see. So this does go to the first limb, not the reasons limb, but the failure to take into account relevant factors
Yes.
limb of the appeal.
It goes to the
And
first.
Ms. Bragahi says they dealt with they considered everything they needed to, and you're saying no, they didn't, because they didn't consider future risk.
Yeah.
It's true they didn't have any material before it, but that's because they hadn't asked for it, which shades into the fairness cross appeal.
My lord, exactly. So it goes to the fairness cross appeal, and of course I'm not suggesting that you can predetermine all the.
Yeah, all right, we've got that. We've got that.
Yes.
Okay.
What a court would have made of that.
Right. Okay. Well, I see the time. You've taken us. What tends to happen if one does this way is you've taken us through a lot of materials, which have generated quite a lot of.
Yeah.
Once you've got to the end of that, what have you still got to do? You've got to actually deal with the issues.
I think I need 20 minutes now.
Yeah.
You've seen
Okay.
all
Well,
the-
we have
I'm
we
sorry,
have 20
Nick.
minutes, so I won't even hold you to that. But we're nearly there, I think.
Yes, I'm sure we are.
Down
Sorry,
on the hard pounding.
I'm really sorry if I was unclear about this. My submission is not that.
No, we got it. We've got it, Mr. Cherokee. Right. Thank you very much indeed. We will sit again at 2. Thank you.
Rise and do walk.